during the course of the hearing.
I understand.
This is in the District Court of Butler County, Kansas. Case is entitled Matthew Gorbold McCardle versus Brooklyn Page. The petitioner, Matthew McCardle, appears with counsel Tony Jones. The respondent, Brooklyn Page, appears in person pro se. We're scheduled today for hearing on two motions. We last appeared on July 2nd. At that time, there was a request by Ms. Page to continue the hearing in order to obtain counsel. The court granted that request over the objection of the petitioner. Ms. Page, I haven't seen an entry of appearance from an attorney. Are you representing yourself here today?
Yes, Your Honor, I am.
All right. And let me address you, Mr. Jones. Have there been any agreements reached on any of the outstanding issues?
Judge, to my knowledge, no. However, I know there has been some communication between the parties, so I hope Ms. Page received the parenting plan that I submitted this morning. I'd be interested to know if there's an agreement on her part with regard to anything in that parenting plan.
All right, Ms. Page, from your perspective, are there any agreements that have been reached between the parties regarding any of the outstanding issues?
Yes, Your Honor, with everything that they have in the proposed parenting plan, I'm agreeing to, except for the only thing I'm asking is that traveling expenses be paid on their end for his parenting time. And then for back child support as well. Besides that, that's about all I can think of and see to try to adjust.
All right, and are we talking about the petitioner's amended proposed parenting plan?
Yes, Your Honor.
All right, I did receive that. Is there a provision in here, Mr. Jones, regarding the payment of travel costs?
Your Honor, the provision in the parenting plan that's been submitted, it provides that I believe they will essentially meet halfway. Yeah, it's on section D on page 2. Unless the parties otherwise agree in writing, father shall pick up the child from mother at the beginning of his parenting time, and mother picks up the child at the conclusion of his parenting time. And this is a case, I'm sure Your Honor will recall, Mr. Gorbold is going to school in Colorado. So there is some distance between the parties.
Right. Now, this doesn't indicate, it doesn't say anything about meeting halfway.
No, I was mistaken in that regard. It's Mr. Gorbold will pick up from Ms. Page and then she picks up at the conclusion of his parenting time.
All right, and who would be responsible for the costs of the travel?
Each party would be responsible. Our proposal is each party is responsible for their own expenses.
All right, was that your understanding of this parenting plan, Ms. Page?
Yes, Your Honor, and that's what I was trying to see if we could come to an agreement. As far as I'm sorry, go ahead.
So my understanding, and correct me if I'm wrong, is that, for instance, if Matthew is going to travel to Kansas, he would pay for those expenses to pick up the child and drive her back or fly her. And then at the end of the parenting time, you would pay for your expenses for the exchange. Is that what the agreement contemplates, Mr. Jones?
That's what our proposal is, Your Honor. Yes.
All right, Ms. Page, is that your understanding?
That's what I understand about it, Your Honor, but I'm trying to get it to be as they're responsible for 100% of traveling expenses for the parenting time.
All right, and Mr. Jones?
Well, Your Honor, as I've indicated, there is a distance between the parties. The parties met, the child was conceived in Colorado. That's where I believe, well, at least Mr. Gorbold was going to school at the time the child was conceived. He's still in school. you know, he didn't have anything necessarily to do with the decision by the respondent to relocate to Kansas. Although it's completely understandable and we're not seeking to penalize anybody, but, you know, essentially we've got two very young individuals, two young parents here, who don't have a lot of resources. We've come up with a plan that, I basically have 4 or 5 exchanges throughout the year for the child. In order to facilitate that, that's why we had asked that the parties each bear some responsibility for that transportation.
Okay, and I guess that's gonna be that was one of the original issues that was brought up that were in dispute, so we may have to flesh that out a little bit. And that was the question I was gonna have is where were the parties living at the time the child was born and so forth, if somebody moved. So I imagine that's something we can all get into here in a minute, but I initially just wanted to see if there was any agreements, and it sounds like the parties are pretty close. We just have this travel expense issue regarding the parenting plan.
As far as the parenting plan, yes, I think that's correct, Judge.
Okay, and then the other issue is the child support component. Have there been any agreements reached on child support?
Judge, there was a temporary order issued. We agreed on an amount of $250 per month. That was above chart from our perspective. And of course, the respondent had imputed a higher level of income to the petitioner. But we agreed on the $250, and he has been paying that since I believe April. And so he's willing to continue to pay that. And so I don't know if there's a dispute on the amount, Judge. But with respect to the arrears, I think the respondent is asking for them basically from birth. We don't think that's appropriate for a variety of reasons, but you know, we would suggest either leaving the child support when it started in April, or at best, when the parties did finally come to an agreement on a mediated parenting plan back in December. So with an effective date of January 1. So, but if my calculations are correct, the respondent's asking for an excess of $5,000 in back child support. Again, college student, very little income now, and he just works over the summers, and doesn't have the ability or capability to pay that. And plus, there would be evidence, Your Honor, that the respondent rejected any efforts of help by the petitioner, leading up to the filing of this case and the mediated agreement in December.
All right, thank you, Mr. Jones. Ms. Page, what is your request regarding the child support?
Your Honor, I'm trying to whatever the state finds fit for back child support. I'd like back child support from the past 2 years, as well as an increase to child support monthly. From my understanding, the $250 was because he was getting a long distancing crediting plan for us, or for him coming here to Kansas from Colorado.
Keep talking.
He sees us. From us as well as for us to travel there. He was supposed to be paying for traveling expenses, and that's never been done.
Okay, well, it sounds like there's no agreement on the child support, and there's no agreement on the who's going to pay for the travel. So the initial motion that was filed was the verified motion to set child support and other relief that was filed by Ms. Page's counsel at the time. She's since withdrawn. And then Mr. Jones, on behalf of his client, filed the motion to set aside or vacate the custody and parenting time order. So what I'd like to do at this time, Ms. Page, is we're going to start out with your motion that was filed on your behalf by your counsel at the time to set the child support and the other relief that she sought in that motion. I had set a deadline for exchanging exhibits. Did you provide exhibits, any exhibits you wish
I-
to?
Your
present
Honor, I
to Mr. Jones?
tried. Oh, sorry, go ahead.
Did you submit exhibits to Mr. Jones?
Both parents clash hard, each refusing to back down on who pays.
I had tried to take them to the courthouse in El Dorado, and doors were locked before 5 o'clock. I don't get off of work till 5, and I had left early a day to go and try to turn them in, and doors were already locked. And I had actually sent an email to Miss Cole, I believe it is, asking her about it and letting her know that I had tried to come to exchange those.
Right, I have those emails, and then Ms. Cool responded to you, then there wasn't any follow-up. Did you
She
make
had
any
asked-
subsequent attempts to get those to us?
Miss Cool had asked for a case number, and I had responded with the case number back, and I had not received anything further from her
Okay.
on
Did
my
you
end.
provide exhibits to Mr. Jones?
No, Your Honor, I did not.
Do you have exhibits you wish to submit?
I have exhibits, but it's over the 10 pages, which would have been in person.
All right, and what kind of exhibits did you have?
They're just text messages with respondent. I have a video of an interaction, anyone called to stand. And then the proposed parenting plan from petitioner.
Okay. But Mr. Jones, and you don't have any of these text messages or videos?
Well, we had put a number of text messages in our exhibit, Your Honor. I don't know if those are identical to what she has. But if the custody and parenting time issues are resolved in the parenting plan, I don't anticipate any need to submit those. If she's talking about text messages that pertain to requests for financial assistance or something of that nature, so the answer to your question is I haven't received anything, Judge, but we don't want that to be an obstacle to us getting this done today, obviously. I'd be curious to know, does she have a child support worksheet?
No, Your Honor, I do not.
Okay. I know there were several proposals submitted as exhibits with the original motion, which I assume you have those. Well, let's go ahead and I'm going to have Ms. Page allow you to argue your motion. Basically, let me know what you're requesting and then why the court should grant those requests.
Okay, Your Honor, I'm asking for the back child support due to financial situations of raising the child. I've been doing it all on my own completely, and it would obviously be very helpful to be able to have some financial help and assistance with raising her and all the expenses that it's taken a toll on throughout the years, as well as now the child support, it's only $250. That doesn't even cover daycare alone, diapers for the month. Daycare is $280 a month that I pay, and I only get $280 a month because I work there, which means I make less money because I work at the school at the daycare, just to be able to keep daycare expenses down. So financially and for the minor child, I just believe it's in the best interest for her and overall to be able to help with it for her needs and everything that she does need.
All right, how old's the child now?
She's 2. She turned 2 in May, Your Honor. 27 months.
All right, and how far back are you seeking child support from?
I'm asking for child support back from the very, very beginning, from when she's been born, from May of 2024. Or sorry, of 23.
All right, what's your name, sir?
Excuse me,
What is your name?
Jared,
All right, you can't be answering questions.
I'll leave, Your Honor. I'll leave.
Okay, you're welcome to hang out.
I'll leave.
All right, so you're seeking child support going back to birth.
Yes, Your Honor.
Which was May 2023.
5/24/23 is her birth date, Your Honor. Yes.
All right, go ahead.
I'm sorry, with what?
I'll continue to argue your motion.
Oh, okay. Just as far as expenses go, I think it's in the best interest for the minor child, um, to be able to get all her needs and everything, help pay for expenses. Like I said, it doesn't even cover anything that's necessities as far as clothes, pull-ups, daycare. He saw her when she was 3 months old, so it's been starting since then, and I haven't gotten any back child support, and the $250 a month is just not cutting it for expenses wise.
Have you been receiving the temporary, the 250 a month, the court ordered earlier in the year?
For the 4 times, yes, Your Honor.
Okay. All right, tell me a little bit about where you all were living, or basically the origin of your relationship. And you all were apparently living in Colorado?
No, Your Honor. He was going to college in Colorado, living there. I went to go visit a friend in Colorado who went to that same college. One thing led to another. Um, I live here in Kansas. I live in Augusta, Kansas. So this is where the child was born and everything is here.
So you weren't living in Colorado?
No, Your Honor.
All right, and so you traveled to Colorado from Augusta to visit a friend?
Yeah, just to visit a friend for the weekend who was there for college.
All right, and you met Mr. McCardle on this trip, or did you know him previously?
No, just met him on the trip.
All right, and then at the conclusion of the trip, you came back to Kansas?
Yes, Your Honor.
All right, have you ever lived in Colorado?
No, I have not.
All right, go ahead.
Your Honor, I think that's about all that needs to be said and argued with, just about the financial expenses that it takes for raising her and everything that needs to be purchased and all the needs and everything that a toddler needs throughout the years.
All right, the other issue of dispute, other than the child support issue, is who's gonna pay for the travel for these exchanges. Go ahead and make your arguments in that regard, please.
Yes, Your Honor. So we do have a text message from um, his from the respondent's father about them having no problem paying for traveling expenses for his parenting time. So and from my understanding from the last parenting visit that he had, it was an agreement that it would be done, no questions, no problems with it. As me being the one raising her, um, I don't have the financial funds to be able to pay for his parenting time and the expenses to travel to Colorado to go get her. So,
All right, and this text message between you and Matthew's father, when did that?
between each other's fathers, yes, Your Honor.
Was that one of the exhibits that you were going to introduce?
No, Your Honor, this was done just a couple days ago, just from the last visit. I believe it might have been Friday.
Okay. All right, anything further?
They had offered if I was nice and cooperative for the next drive pickup for him for his parenting time, that they would pay us $1,000, and that was it. Just for back child support, that was all they were offering, but only if I was cooperative. So besides that, they had refused to pay any back child support.
All right. Thank you, Ms. Page. Any other argument you wish to make in support of child support or travel expenses?
I don't think so, Your Honor. I think that's all.
All right, Mr. Jones, I'll allow you to make argument this time.
Thank you, Your Honor. So with respect to the child support, I have in the packet before you, Your Honor, Petitioner's Exhibit 2, which is the DRA of Mr. McCardle, Exhibit 4, which is the DRA that was provided by Ms. Broyles of Ms. Page. And with that information, I had prepared what I've offered as Petitioner's Exhibit number 3, which is a child support worksheet that reflects Mr. Gorbel McCardle's current income. And his current income, Your Honor, is for summer employment that he maintains. I think it's almost an internship, if I'm not mistaken, but he does get paid for that. And for that 3 months of employment, we have reduced that to a monthly amount. And that is the only income he has right now. And I also point out, and this is material, I think, for later on in the worksheet. I'm just going to refer to him as Matthew, Judge. It's like getting tripped up over Gorbel and McCardle. So Matthew lives with his parents, and his parents still support him. They live in Colorado where he attends school. Other than his tuition, which is an out-of-pocket expense, obviously, he has very limited income, and certainly his expenses. And I use the income from Ms. Page that was provided in her DRA. The only adjustments that were made on the worksheet, Your Honor, was the cost of living differential. It was a small adjustment based on him residing in Colorado, and an adjustment for taxes. I believe that was calculated based on the assumption that, and I better double check this before I open my mouth on it. With regard to taxes, I believe that the current order provides that Miss Page will be claiming the child on taxes each and every year. But that was, again, a small adjustment. We did not include an adjustment for long distance parenting time costs. The reason we did not include that, Judge, is that was something we were seeking
A
to
worksheet shows 0, yet the father still steps up to pay.
apportion between the parties. If, as the respondent is requesting, the court deems it appropriate to require Mr. Gorbel McCardle to pay the entirety of the travel expenses, and I think that would be an appropriate adjustment on the worksheet as well. Now, I talked about where he was living and the fact that that Mr. Gorbel McCardle is basically a dependent. The worksheet with the application of this what do they call it, ability to pay calculation, came up with a 0 amount because of his dependency status, and we thought that would be inappropriate to include that. And that's how we came up with the amount of, well, our worksheet shows he should be paying $235. He's agreeable to continue to pay the $250 and to continue paying that until there's a change in his situation or a change in the situation of the respondent, such that a modification would be appropriate. And hopefully that'll happen sooner rather than later, Your Honor. But
the
right.
proposed worksheet I have shows him paying 0.
But that's what I was explaining, Judge. The Bradley software would not let me take out the ability to pay calculation. So it says if you make below $1,304, you don't have the ability to pay any child support. Well, his monthly income is $1,244. So the worksheet spitting out a number says it should be 0. But to me, that seems counterintuitive, Judge, because my client is a dependent. So he doesn't have the same living expenses that somebody living on their own would have, if that makes any sense.
All right, I understand the argument.
Okay. And then in terms of the effective start date of the child support, I believe the motion that was filed by the respondent referred to this open and notorious declaration, and their evidence of that was a message between the petitioner and the respondent. Now, that doesn't strike me as notorious in that it was a communication between the parties. So again, I would point out that this motion or this petition was filed by Mr. Gorbold McCardle, has been prosecuted by Mr. Gorbold McCardle because he wants to have a relationship with his child and be involved. He wants to support his child. I think the exhibits that we've tendered to the court, including text messages, specifically petitioner's exhibit number 6. There are statements by the respondent that I'm doing perfectly fine supporting me and the child. You're not her father. You don't deserve that. Sorry, you're not. I don't want your money. I mean, there were attempts. And I'd also point out that within our exhibits, Mr. Gorbold McCardle had put together an itemization of items and money that he did provide to the respondent. And those are contained in petitioner's exhibit 13. Now, again, these aren't necessarily consistent or necessarily significant amounts of money, but they do represent the attempts by Mr. Gorbold McCardle to help support his daughter, and certainly he's ready and willing to do that today. Again, he's in school. As soon as he gets out, it'll be appropriate, and I will discuss with Mr. Gorbold McCardle his obligations to notify the respondent when he has a change in income or circumstances as required under the guidelines. The last point is to the transportation. That has been a problem. The visitations that have occurred were the result of agreements that were made in mediation or that original parenting plan. Unfortunately, for whatever reason, that plan did not contain any terms regarding payment of expenses or child support or anything of that nature. I don't know why that was the case, Your Honor, but that led to disputes and then, parenting time not occurring because he wouldn't do these things or wasn't paying child support. But they were able to work through that, Judge. And I think there was even a period of visitation this last weekend, as Miss Page indicated, that it would not be appropriate to now go back and assess child support for a period of time from the birth of the child, where he's had a limited role and a limited ability to participate. And granted, Judge, they live a great distance apart, and that's through no fault of either one of them. They both were where they were when the child was born. That's certainly going to change over the next few years. So at this point in time, based on where they're at, we would ask that the support ideally would just continue where it's at. He's been paying since April. That the alternative being, if you started the child support January 1 of 2025, that's the $1,000 that she's talking about. 4 months at $1,000 or 4 months at $250 a month would be. So I think that was just part of some last ditch efforts to get this resolved, so we wouldn't have to consume the court's time. And I do want to acknowledge that and appreciate that they were able to come to some agreements, some major agreements on the parenting plan, and hopefully that'll be a good sign of things to come. But in terms of resources and ability to pay, that would the back child support would just create a significant burden and obligation on the petitioner and would not be of any benefit to the child as he's trying to work out times and places to exercise some parenting time with Hadley, hopefully as soon as this weekend.
All right. Do
Your
you,
Honor,
hold on just a minute. Mr. Jones, do you dispute the um, origin story, so to speak, of the uh, party's weekend in Boulder, where the child was apparently conceived? Do you agree that that's the situation between these parties?
Yes, Your Honor.
Okay. All right, Miss Page, I'll allow you to respond.
Your Honor, I have allowed him to stay at my home for part of his parenting times to help him with expenses. As far as it goes to no job, no money, I have a job, but I also have bills and responsibilities to pay, as well as a 2-year-old that I have to pay for and everything. Um, I've went to Colorado twice now, and I've had to pay for everything as far as gas, hotel, food, anything we did. All those expenses came back to me, and it puts us in a very hard financial situation when I have, like I said, I have a home for me and my daughter. Um, that rent alone is just $1,000 a month. So I have utilities, I have groceries I have to pay for. I mean, everything. It all adds up. So I
All right,
believe it's only fair and in the child's best interest to be able to get help, to be able to continue doing things that she loves and things that she needs.
all right,
It's
and
not cheap raising a kid.
Ms. Page, tell me a little bit about your employment situation.
Yes, Your Honor. So I work here in Rose Hill, Kansas, at the primary school. It's called Kids Club, and I believe my pay right now is $13.50 is what I make an hour. But continue working here due to keeping my baby's costs down for daycare. So, like, if I were to go somewhere else and get higher pay at a different job, really it wouldn't. It would just even out because daycare, I pay $280 a month. Daycare at most places is like $280 a week, if not more. So it evens itself out. And that's where she'll be going to school at. So it's got her in a routine. It's got her knowing everybody. Um, Yeah, so I help with children there. It's kind of like a daycare, just until kids reach the age to go to pre-K, or we get like after school kids when they're done and that type of situation.
Do
So,
you intend for this to be a long-term employment?
yes, Your Honor, as far as keeping daycare costs down, expenses like that, yes.
Okay, and Mr. Jones, tell me about Mr. McCardle's college situation. How much longer does he have to go?
Your Honor, I believe he just started his 4th year. Is it University of Colorado, Matthew? His 4th year at the University of Colorado. We're looking at a graduation date in May of 2026.
Okay, and what is he studying?
Electrical engineering, which is a very good field right now.
And his intentions upon graduation, known or unknown at this point?
I believe that's still up in the air, Your Honor. But again, I think he's in a good field for the current environment right now, and we're confident. He does intern with companies over the summer, and that may lead to opportunities. And certainly he's got to weigh his situation with Hadley as well, and trying to be a co-parent with that moving forward. So, but that's the anticipated graduation date, and that's when I think at a minimum, some of these numbers are going to change.
All right, and he doesn't intend to pursue any sort of graduate school?
I think that may be you're shaking your head, Matthew. Is that you're not considering that now?
I may consider it if I do not get a job.
Okay, but I've explained to him graduate school is different than your undergraduate. years in terms of what the expectations are. So either way, I think there's going to be a change in the numbers regardless of what happens.
Okay. Mr. Jones, you've submitted this notebook, you've referenced several of the exhibits. Are you seeking the admission of those exhibits?
Yes, Your Honor. I referred to exhibits 2, 3, 4. I think we referred to number 6 and to number 13. And then, of course, the amended parenting plan that was emailed this morning, I would file that. Well, I mean, I may make changes to it based on your decision, Judge, but that's what I'm anticipating incorporating into a journal entry.
Support, travel rules, and even passports getting nailed down tight.
Journal entry and again, with any modifications or orders issued by the court.
Okay. All right. Exhibit 2 is your client's DRA, which is that on file with the court?
It should be, Judge.
And then exhibit 3.
I believe, yes, that the DRAs and the child support worksheets were all filed at the time the motion to establish the child support was filed.
All right. Ms. Page, do you have copies of all of these exhibits?
Yes, Your Honor, I do.
All right. Do you have any objection to these exhibits being admitted?
No, Your Honor.
All right. I'll admit exhibits 2, 3, 4, 6, and 13. Were there any other exhibits you were seeking to admit, Mr. Jones?
No, not at this time, Your Honor.
How old are the parties? Ms. Page, how old are you?
I'm 20.
Okay. Mr. McCardle, how old's Mr. McCardle?
Go ahead, Matthew.
I'm 21.
Okay. All right. Any further argument in support of your motion, Ms. Page?
I think there's one more thing with the parenting plan that they proposed, being a passport they wanted by next year, September 1st. I don't believe that's the best thing. I would like to wait for at least until she's 4 years old, being that they're from Scotland themselves. I just don't want to take any risks of going there and never bringing her back, and just things like that that can lead up to it. And I'd like for them to be able to build a relationship together before traveling that far in the distance and whatnot and taking her there. But besides that, I think that's it, Your Honor.
Mr. Jones, your response?
Yeah, we had put a provision in there that the parties would cooperate in getting a passport and an agreement that there'd be no international travel with the child until basically a year from now. So, if that's an option and available during Mr. Gorbold McCardle's parenting time, I mean, certainly that's going to take some planning and some involvement by the respondent in there. There's nothing planned to happen with this judge, but as she indicates, he has family in Scotland. I'm going to give the benefit of the doubt that it's just a worry or a concern, but there's no suggestion or nothing to there's no action or statements on the part of my client to suggest that he would attempt to remove the child from the country. Scotland is I'm sure is a participant in the Hague Convention, and of course he knows that not complying with the parenting plan and denying parenting time or visitation would be the end of his custody or parenting time at that point. So again, I'm just asserting it as a concern, but I don't think it's a realistic one and shouldn't be considered by the court.
Your Honor, if I may too, I'm fine with them traveling in the U.S. with Hadley or with the child as well. Whenever he has his parenting times, as long as it's in with the states, it's fine. I just am not comfortable, and I don't think it's in her best interest for the passport until there's a relationship built with the minor and him. So
So you're basically, the proposal is 2026, and your request would have it be 2027?
Yes, just until she's the age of 4, Your Honor. Yes.
Okay. All right, well, absent an agreement, I can rule on that if the parties are wishing me to at the appropriate time.
Yes, Your Honor, please.
Yes,
right.
Your Honor.
And Mr. Jones, anything else regarding the two issues regarding child support and travel expenses?
No, Your Honor.
All right, Mr. Jones, do you wish to make argument on your motion now, or wait until I rule on this first motion?
Well, I think my motion may be kind of moot, Judge,
Okay,
because the parenting plan that was originally ordered expired on its own terms this month. I don't know that we necessarily need you to set aside anything. We just need a parenting plan to continue on from August, well, from what'll be this weekend.
all right. Okay, if you all give me just a couple minutes, I want to go over these exhibits that have been admitted, and then I'll be in a position to make a ruling. So I'm going to go off camera for just a couple minutes. If please don't leave the meeting. If you need to get up for a second, feel free to do that.
Okay,
we'll
thank
take-
you, Your Honor.
We'll take a short recess. Now, I've had an opportunity now to review the contents of the court file as well as the exhibits that have been submitted. And I've listened to the arguments and statements of counsel. These parties have gotten themselves into a very serious situation at a young age to have to juggle the long distance and having a child at such a young age in their lives. So it makes for some difficult financial considerations and decisions on travel and parenting time. I appreciate that through the course of the case, the parents have, at least initially, through mediation, had come up with the initial parenting plan, and apparently a parenting plan, for the most part, has been agreed upon here, minus a few modifications that have been asked for the court to decide. In going through the child support worksheets, the worksheet the court finds most appropriate in this situation is the worksheet submitted. It was Exhibit C in the original motion filed by Ms. Page as counsel, and the one I believe she was advocating for today. I think the income figure attributed to Matthew is most appropriate in this worksheet. This is for the $250 a month, giving him a long distance parenting time costs and income tax consideration adjustments. So that's going to be the worksheet the court adopts. And I'm going to make this worksheet retroactive to January 1 of 2025. Now, the issue regarding back or a judgment for child support going back to birth, looking at KSA 23-2208, the presumption of paternity, of course, it's KSA 23-2215 gives the court the ability to order child support dating back to birth. I think in this case, you've got Matthew, who is obviously reaching out, making attempts to see his daughter or contribute financially. Those attempts are, for the most part, denied by Ms. Page. The presumption of paternity statute previously referenced states the man notoriously or in writing recognizes paternity of the child. I think Mr. McCardle was recognizing in writing or through text message or however the communications were coming in, that he's the father. There was no dispute over that. So weighing into consideration the fact we've got a young mother who probably not exercising the best judgment was denying his attempts at support. And weighing in the fact that Mr. McCardle was making attempts to see his daughter. He's the one who initially or filed the petition for paternity. I'm going to balance those two factors and award a $1,000 judgment for pre-2025 child support. So that would be $1,000 judgment from birth to when the January 1, 2025 worksheet will take place. Regarding the travel expenses, the court has given an adjustment in the worksheet to Mr. McCardle. I'm going to order that it be his responsibility to pay for all of the travel costs for the parenting time. I think the burden that Ms. Page bears by being the residential parent and covering the day-to-day costs. And Ms. Page, we've lost you.
Sorry, we're here, Your Honor.
Taking that into consideration and the fact that the amount is fairly low at this point, based primarily on the income ability of Mr. McCardle. Now, obviously, that will change at some point in the future. I assume his income earning ability will substantially improve upon graduation from college, or at least you would think so in this day and age. That's undetermined, but so those are the orders of the court regarding child support, travel expenses, and back child support. The request to resolve the passport issue, I think Ms. Page's request to bump a year on that is appropriate. So the order of the court will be that there'll be no international travel until after September 1, 2027. It doesn't sound like that's going to interfere with any current plans that are in place. So I think that would be appropriate. Let the child get a little more age and under her belt before she embarks on the international travel. All right, Mr. Jones, do those orders satisfy what's been requested or what's left to resolve in your opinion?
Yes, Your Honor, with the exception of, are you going to then incorporate the amended parenting plan into your final order with those changes?
Yes.
Okay, then yes, that would address everything.
All right, Ms. Page, do you feel that the court has addressed all of the pending issues?
Your Honor, if it's possible too, I'd like to have child support be going through the Kansas Pay Center. I believe that's the best way to do this child support
It
payments.
should be going through the Kansas Payment Center already, is it not?
No, he just cash apps it, Your Honor.
Okay, I wasn't aware that that was going on. Well, it needs to go through the Kansas Payment Center. If you can put that appropriate language in the journal entry, Mr. Jones.
Yes.
and
Yes.
direct-
Arguments erupt as every cause becomes a battlefield of words.
and
Yes.
direct your client to send it there. Otherwise, he's not going to get credit for those payments. And I'd like to resolve that issue while we're here today on any payments that have been made under that temporary order made by the court, that those be credited towards that temporary order that the court made. Are you acknowledging that, Ms. Page?
Yes, Your Honor.
I don't,
Matthew, how many payments have you made? Is it 4 or 5?
4.
I have made 4.
Okay, so that would be May, June, July, and August?
Correct. That would be $1,000 total.
Okay. So we'll reflect payments of the $1,000 from May to August.
I think that should be reflected in the journal entry and that be credited towards him for the payments made under that temporary order, which I don't recall as I sit here today, what date that order was made. It looks like that order was made on April the 28th, 2025 at that initial motion hearing. All right, anything else, Ms. Page, that you feel the court hasn't ordered or addressed?
I don't believe so, Your Honor.
All right, Mr. Jones, do you anticipate doing a Rule 170?
Yes, that's what I anticipate, Judge. The only thing is the parenting plan provided for parenting time from August 29th to September 1st. If this isn't signed, I'd like to make it clear that's the plan we're gonna follow, pending the 14 days or the signature of Miss Page.
Are you agreeing to the August 29th parenting time?
The only thing with that, Your Honor, is the 6 p.m. pickup time. That's too late for the drive there. If I'm having to go there to get her, that's too late considering I have work and she has daycare that next morning.
Well, I think the court just ordered that Mr. Gorbel McCardle be responsible for transportation. Is that correct, Judge?
I was ordering that he pay the transportation costs.
Oh, okay. So what is she proposing?
Either an if they would like to, sorry, Your Honor, can you hear me?
Yes.
If they would like to bring her back, and they want to bring her back by 6 p.m., I would be fine with that happening. It's just too late of a drive for us to have to go there, Your Honor.
All right, is that agreeable, Mr. Jones?
I'll let you weigh in on that, Matthew.
So just to confirm, she's asking if I drop her off instead.
Yes.
Yes, we could do that if that works better.
Okay, that works.
All right, and Mr. Jones, hopefully the parties that will follow through on both ends here to make this happen. In the event there's a concern if you wanted to prepare an order specifically for that parenting time with the intent that it gets signed and filed prior to this parenting time to begin, I'd be more than happy to do so. And then do a Rule 170 on the remaining issues. I assume Ms. Page could authorize a electronic signature upon receipt of an email with the proposed order.
Yes, Your Honor.
So I will email that out to you for your approval. If you have any objections, you need to let me know as soon as possible.
The only thing I can think of too is moving forward with traveling, as far as pickup and drop off with that, time wise, just kind of like stated here, the 6 p.m. time. Unless they'd like to drop off, then that would be fine. And then back child support, when is it that has to be, when is it that that has to be paid for him?
Mr. Jones, do you have a proposal in that regard?
Well, I heard you say, Judge, you were going to grant a judgment for that. I can talk to Mr. Gorbel McCardle about a payment. I would assume this amount would be reflected in the payment records of the Kansas Payment Center by virtue of it being a judgment, and to make arrangements to get that paid. But I don't have a specific date when anything can be paid, other than the 250, which will be due next week.
What about within 6 months?
The $2,000,
Yes.
can you commit to that, Matthew?
I'm sorry, I'm catching up on $2,000. I thought it was 1,000 for the pre-2025.
It was, but there's 1,000 for 2020, January 1, 25 to April 2025.
Okay. So yeah, I can do that within 6 months. Yeah.
Okay, so if you want to put that in the journal entry, Mr. Jones, as well.
Your Honor, one other thing too, as far as them covering traveling expenses, how is it that that will work out? Will there be a time frame that a certain amount's paid beforehand, before that date? I just want to make sure that there's no miscommunication on that part.
Well, I don't know what it costs to drive back and forth to Colorado or to Boulder from Augusta. I would suggest keeping track of fuel receipts. Or is there an overnight stay involved?
Yes, he has overnight stays, Your Honor. Or yes, Your Honor, there is overnight stays.
I think it's how long is the trip?
About 7 hours.
That would be tough to do there and back in one day, so there may be accommodations if that's what you're asking, Judge.
Right, what I was thinking was the cost of fuel and the cost of one overnight stay at, I'm not talking at the Ritz, but at a, a standard hotel.
May I say something, Judge?
Sure.
My intention was to minimize the transportation time, and to fly back and forth for pickup. I don't know if that would be okay with Brooklyn as a different option.
That would probably make it easier to book air flights back and forth without
Then in that case, there'd be no expense, I think.
correct. And
Yes,
then,
Your Honor, if that's easier for them to do if they like to pick up and drop off that way, if that's easiest, that's the best option there is. That works with me.
all right, then I assume, Mr. McCardle, you would purchase the plane tickets in advance and forward the appropriate information to Ms. Page.
Yes, and may I also ask if we can do the meetup to hand over at the airport?
That's fine. That works with me.
Okay.
All right, any other issues that,
Last detail, I promise. Which airport?
The ICT airport in Wichita.
Thank you.
Your Honor, I just want to make sure too that all essentials will be provided by him. He'll have what he needs for her, just coming here to pick her up and whatnot, having the diaper bag and everything needed for her.
I would expect that he would have all of that stuff with him.
And vice versa, he needs to be made aware if there's any medical issues or medications or there's things like that's essential that you provide that as well.
Yeah, he's got all the medical records as well to be able to see all that too, but I'll definitely do what I need to do on my end to notify him if there's medication or something that she's taking.
All right, anything else?
I would like to ask, Your Honor, that information has previously been withheld on previous visits.
I hope the parties aren't doing that, either one of them. Make sure you've got everything that she needs to
Yeah.
make these flights and accommodations as less stressful as possible. You all are young. It's a young child. You're in a tough situation. You all are going to have to be dealing with each other for the foreseeable future. So hopefully, you guys can make this less stressful on everyone, and especially for Hadley. So I will make a final order that these agreements and orders are in the best interest of the minor child. With that being said, I'm afraid to ask if there's anything else, but is there anything else?
No, Your Honor.
I don't think so, Your Honor. I think
All right.
that's it.
Ms. Page, just make sure you're checking your email to look at these documents. If you feel that they accurately reflect what the court has ordered, please authorize your e-signature. Now, this isn't whether or not you disagree. You may disagree with something that I've ordered.
Right.
This isn't to object because of that. It's just to make sure the documents accurately reflect what I have ordered. So,
Yes, Your Honor.
all right. With that being said, if there's
And that's it, guys. Justice Land Heavy, case sealed shut. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.